Good afternoon, and welcome to the American Constitution Society's annual Supreme Court Review. I'm Russ Feingold, and I'm president of the ACS, and it's the country's foremost progressive legal network with nearly 200 student and lawyer chapters across the nation. Through our diverse nationwide network of progressive lawyers and law students and judges and scholars and advocates and many others, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, that uphold the rule of law, and that redress the founding failures of our Constitution and the enduring inequities in our law in pursuit of a realized equality. So if you're not already a member, I'd encourage you to become a member of ACS. Go to acslaw.org, where you can join and find more information about events like this one. A few quick housekeeping notes before we begin. This afternoon's discussion is being recorded, and the recording will be available on ACS's website after today's program concludes. For those interested in CLE credit, information is available in the chat. Finally, there will be time during today's discussion for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat to ask your questions, as we will not actually be monitoring it, and your question will therefore not be put in the queue. If you are a member of the press, please include the name of your outlet at the beginning of your questions. This term began with the historic and landmark welcome of Ketanji Brown Jackson as the first Black woman to serve on the United States Supreme Court. Despite the excitement around her arrival at the court, progressives, of course, were under no illusion that the 6-3 conservative supermajority would somehow suddenly halt its attack on the fundamental rights or its project of advancing the goals of the conservative legal movement. Although on a couple of occasions, it showed some unexpected restraint in voting rights cases and a few other areas, the court continued to flirt with and in some cases advance fringe right-wing legal theories that threatened the very foundations of our democracy. And the court continued its project of unwinding protections in areas ranging from labor and workers' rights to environmental regulations to non-discrimination laws and, of course, affirmative action. So what do these decisions mean going forward? When all is said and done, what is the legacy of this term? To help lead our panelists in considering these questions, it's my pleasure to introduce our moderator, Chris Geidner, the publisher and author of Dork. Chris has written for numerous national publications and appeared on CNN and MSNBC to discuss the Supreme Court. He previously served as legal editor and Supreme Court correspondent at BuzzFeed News. Prior to his career as a legal reporter, Chris practiced law in Ohio, both for a private firm and in the state government. So as you can see, we're in great hands here with Chris leading today's discussion. Chris?
Thanks so much, Russ. I really appreciate that. And I appreciate the fact that ACS has given us a really great opportunity to bring together some of the leading voices of discussing these key cases that the court decided this term. And I think that it is important when we were discussing how to put this together and when to put it together, we talked about the importance of actually giving a moment that ACS is an organization. I helped co-found the Columbus Lawyer Chapter back in the day. It's an organization of people who like thinking. And that might be a little different than some other places where they're just focused on getting judges on the bench. And I think that giving us a week or two here to sit with these cases, think about them, and have this great panel of experts together to talk about what just happened will give us a chance to get a little more in depth than if we had asked for sort of the day one or day two take of the court. So I'm really happy to be here. Thanks so much for asking me to lead, and let's get underway. This was, as Russ said, a term of increased extremism, but it was also a term where there were some moments of holding back, what I've pointed to as sort of the court being aware that it's being watched. And I think to start that, there's no better person than Steve Vladeck, who obviously is known to a lot of people here for his work publishing a new book, The Shadow Docket, but his day job at the University of Texas, Austin School of Law, where he's the Charles Allen Wright Chair in Federal Courts, gives us two key ways to look into what we've been dealing with from the court this term. So first of all, welcome, Steve. Glad to see you on a Zoom as opposed to just on one of the 18 social media networks.
Thanks, Chris. It's great to be with you, and I promise not to make any plugs for new networks that may or may not rhyme with threads. So I've got about 10 minutes to cover 4 cases, although it's 4 cases that came out as 2 decisions, the student loan cases and the Section 230 cases. And I'm probably going to spend most of my time on the former because the latter turned out to be a bit of a dud. So the student loan cases, I think probably everyone watching this is somewhat aware of the fact that the Supreme Court struck down President Biden's student loan debt cancellation program, finding that it was not authorized by the relevant statute, the HEROES Act of 2003. There actually were 2 student loan cases. I actually think it's important not to completely gloss over the first one. So in the first one, Department of Education versus Brown, Justice Alito actually wrote for a unanimous court in holding that 2 private plaintiffs lacked Article 3 standing, that they couldn't show the requisite injury in fact, causation, redressability that we all learn about in law school, because they couldn't show a direct connection between the relief they were seeking and the program they were challenging. And the only reason why I think that's worth noting is, given what the court was about to say in the other student loan case, a unanimous court insisting on the sort of formality of Article 3 standing was one thing. But it's also worth reminding folks that the district court had held otherwise in issuing a nationwide injunction against the program, Judge Pittman in the Fort Worth Division of the Northern District of Texas. And the Fifth Circuit had refused to stay that decision, agreeing with Judge Pittman's standing analysis, one of 3 different times this term that the Supreme Court's analysis of Article 3 standing was much narrower than the Fifth Circuit's. Winona's going to talk about, Burkine, Holland versus Burkine, where that was also at issue, and there's also U.S. versus Texas. So, I think that we shouldn't lose complete sight of the fact that the Fifth Circuit got slapped down, even as the student loan program did as well. Turning to Biden versus Nebraska. So there are obviously 2 major holdings in Chief Justice Roberts' opinion for a 6-3 majority. The first is the standing holding. In a nutshell, the court held that Missouri at least had Article 3 standing because MOHELA, a state actor, would have been, could be, might be, is injured by the program insofar as it's a loan service or at least a loan coordinator. A couple problems with this. One, MOHELA was created by Missouri to be independent of the state and not actually the state itself. Missouri created MOHELA with the power to sue and be sued, at least in part to insulate Missouri from claims against MOHELA. MOHELA didn't want to challenge the student loan program like most loan servicers. And in holding that Missouri has standing because of the injury to MOHELA, the Supreme Court made new and I think completely disingenuous Article 3 standing jurisprudence, holding that a state will suffer an injury when any state actor suffers an injury. Just to drive home how broad that is, I teach at a public university. Ruben teaches right. I mean, we are employees of public universities. We are state actors. By that logic, if I am injured by a federal policy, Texas can sue to challenge that policy because I am part of Texas. That is a remarkable expansion of Article 3 standing. It really seems to run roughshod over the notion that injuries have to be both concrete and particularized. And it's, I think, especially troubling because for 50 years, it has been the conservative justices who have been behind the movement to sharpen the limits on Article 3 standing in the name of limiting the power of unelected judges vis-a-vis the democratically elected political branches. The irony of the conservative majority blowing a hole through, driving a Mack truck through the middle of limits on Article 3 standing doctrine in order to strike down a program enacted by a democratically elected president, I think ought not to be lost on us. So, I know folks are going to focus on the merits of the student loan decision. I think we shouldn't lose sight of just how problematic the standing holding is. And indeed, I'm writing about it this week for my newsletter, One First, about the Supreme Court, which, in addition to Law Dork, Chris's new newsletter, folks should take a look at. Turning to the merits, I think it's worth starting by actually quoting the relevant language of the HEROES Act, because the language, well, judge for yourselves if this is ambiguous. So I'm going to read from 42 U.S.C. section 1098 BB subsection A1. The Secretary of Education may waive or modify any statutory or regulatory provision applicable to the student financial assistance programs under this title as the Secretary deems necessary in connection with a war or other military operation or national emergency. This is not a general grant of authority. This is a specific grant to respond to crises. Indeed, the HEROES Act of 2003 was an amendment to the 2001 HEROES Act, passed right after 9/11, where Congress in 2003 was making this authority available after any national emergency, like the COVID pandemic. Ultimately, the problem with the statute is not that it's ambiguous, it's that it's really broad. And it gives the Secretary of Education an awful lot of power, power that obviously the conservative justices don't think he ought to have. And that's a perfectly reasonable policy position. But the notion that the statute is not clear simply because it uses broad language is, I think, problematic. All right. But even if you believe that language is ambiguous, even if you think waive or modify any statutory or regulatory provision doesn't actually mean waive or modify any statutory or regulatory provision, it used to be not that long ago that ambiguity would not end the case. Ambiguity would simply open the door to bringing in other types of interpretive tools, canons of statutory interpretation, what have you, to try to resolve the ambiguity. The problem here is the ascendancy of the so-called major questions doctrine, the idea that Congress must speak specifically whenever it intends to authorize agencies to promulgate policies with, quote, vast economic or political significance, unquote. Well, there are a couple problems with this. Number one, at the time this statute was enacted, the major questions doctrine as such didn't exist. So even if you think the major questions doctrine is a viable theory, the notion that Congress somehow knew when it passed the HEROES Act that this language would be insufficient, that it had to specifically say 17 years from now, when there's a pandemic we can't contemplate and we can't predict, we want the secretary to have this specific authority, is kind of revisionist history. But second, and even more importantly, there's such profound subjectivity in the question of which policies are of vast economic or political significance. Now, in the case of the student loan program, I actually think it's not that subjective, whether it's of vast economic significance. I mean, it's an awful lot of money. We're talking hundreds of billions of dollars. But the problem with what the decision sort of does is what it opens the door to. Because now, with such a robust major questions doctrine, after this decision, after West Virginia versus EPA last term, you have the specter of any district judge anywhere in the country deciding for him or herself that a particular program is of vast economic or political significance, and then relying on ambiguous language in the statute to say it's unauthorized. And as we saw in this case, applying that approach to statutes that are decades, if not half a century old. Think programs like Medicare, Social Security, everything under the sun now becomes open season. And so my biggest concern about the student loan decision is not just how the majority runs roughshod over standing. And it's not how it expands the major questions doctrine even further. It's how if you add those two things together, it creates basically an open season for not even red states, for states whose political leadership is opposed to the incumbent president to find the nearest friendly district judge, argue that the policy is not authorized under the major questions doctrine, obtain a nationwide injunction, then we're off to the races. And that's government by injunction, and really sort of enhancing the power of the federal courts in general and the Supreme Court in particular, a massive expansion, I think, right, in the years to come. So that's the good news in the student loan cases.
The great news.
Yep.
I just want to, before you go on to the 230,
Yeah.
huge 230 case, I want to remind everybody that please, as we're going forward here, if you have questions, I imagine there will be questions about this case, even though we're going to go through all of the cases first, please put them in the Q&A below on your Zoom. In addition, if you are here for CLE, I want to give you the first of your code words. The first code word is cookout. So if you are doing this for CLE, your first word is cookout. Speaking of cookout, there for a bad segue, tell us about what happened to the flaming Section 230 case.
Yeah, I was trying to think of how I would turn cookout into a segue, and I couldn't do it. So, these were also supposed to be, I think, at least at the beginning of the term, two of the biggest cases the court had this term. Section 230 just is shorthand for Section 230 of the Communications Decency Act of 1996. This is often known as the statute that gave rise to the internet as we know it, or that's responsible for the modern internet. I mean, you name it, Section 230 is pegged for it. And Section 230 has become a bit of a bête noire in the right-wing media in recent years on the theory that it's Section 230 that's somehow responsible for every perceived bad thing that social media companies do. And indeed, Justice Thomas had written a series of opinions respecting denials of certiorari where he had urged the court to revisit the scope of Section 230, because what Section 230 does is it says if you are a website, an electronic service provider, you are immune both from content that others post to your site. So Twitter's not liable for tweets that I post to its site. And you are immune from liability if you take down content for being in violation of your terms of service. And so it's basically protecting the hosts and the providers from being sort of endlessly subjected to lawsuits. 230 has been interpreted quite expansively in the lower courts, but not that inconsistently. And so that's part of why when the court took up these two cases, Gonzalez versus Google and Twitter versus Tamina, I think there was a widespread concern in the tech community that the court was looking for an excuse to narrow the scope of Section 230. And then something strange happened. And the strange thing that happened is the justices read the briefs and had oral argument, and I think realized that it was interjecting itself into an incredibly complicated policy debate about what the law ought to be as opposed to what the law is. And basically the justices said, you know what, we're good. And so they looked for an off-ramp. And the off-ramp they found was actually to rely on a separate problem in the Twitter case, in Twitter versus Tamina, about the scope of the Anti-Terrorism Act, the statute that the plaintiffs in that case had sued under. So, both of these cases involve claims against Twitter, against Google and YouTube, arising out of how those sites had facilitated ISIS and ISIS-related propaganda that had helped facilitate, allegedly, ISIS-inspired terrorist attacks that had killed or wounded U.S. service members. And what the Supreme Court held in a unanimous opinion by Justice Thomas in the Twitter case is that the Anti-Terrorism Act actually has a higher standard for aiding and abetting liability, for the secondary liability the plaintiffs were seeking to impose on these companies than the lower courts had held. And by ratcheting up the standard, the court was therefore able to duck the Section 230 issue, because it means that Twitter and Google would both win in the lower courts on the cause of action question before we ever got to whether they were immune from these lawsuits. right? The lower courts could just say you plaintiffs didn't have a claim to begin with. Really quickly, I mean, that's good news for Section 230. I wrote an amicus brief in Twitter versus Tomina that actually argued that the lower courts were right about the Anti-Terrorism Act. I don't think the Supreme Court was right about the scope of aiding. I mean, Congress in the purposes section of the 2016 amendment to the Anti-Terrorism Act said that it wanted to confer aiding and abetting liability to the maximum extent allowed by the Constitution. The Supreme Court kind of ignores that provision in its opinion. But I think that, sort of a narrower interpretation of the Anti-Terrorism Act was the sort of the compromise to avoid saying anything about Section 230. Instead, and Chris, this is probably a good place for me to stop, I think the real fight about big tech is going to be next term, when the court is going to have to take a pair of cases from Texas and Florida, I think best known as the net choice cases, where these are challenges to copycat laws passed in Florida and Texas that effectively ban large social media providers from engaging in almost any content moderation. Both district courts held that those laws violate the First Amendment. The 11th Circuit affirmed the injunction of the Florida law in an opinion by Trump appointee Judge Newsom. The Fifth Circuit reversed the injunction of the Texas law, an opinion by Trump appointee Judge Oldham. And it seems like that's going to be where the fight really is had, Chris, because it's really, I think, the First Amendment question about whether big social media companies are common carriers, about whether they have First Amendment rights of their own. That's where the fight's really going to happen. And just as a really quick last point, the Supreme Court could get as early as this week an emergency application in a case called Missouri versus Biden. Hard to keep these all apart when the states are always the plaintiffs. This is the one where Judge Doughty in Louisiana ruled on July 4th, issuing an injunction barring basically almost any executive branch official from talking to almost any employee of a social media company. That issue, I think, is in that case too. But Chris, I think the big fight over big tech is really for next term.
Thanks so much, Dave. I think that that was a good example of sort of two of the functions that we saw out of this court, sort of deciding cases full on versus dodging what was initially thought of as a potentially blockbuster, earth-shattering case. However, next up is another case where they certainly didn't avoid their decision. Kelly Moser, so glad to have you here, the senior attorney and leader of the Clean Water Program with the Southern Environmental Law Center, is here to talk about Sackett versus EPA. So what happened there, Kelly?
Chris, it's great to be here. You'll see my smile, though, a little as I get into this decision, because I'm going to be talking about Sackett v. EPA, which is a terribly disappointing decision with long-lasting effects on the scope of the Clean Water Act and on agency authority to protect human health and the environment. It was not all that unexpected, but quite disappointing. So I'm going to just give a little bit of background on how we got to where we are today in Sackett, and then I'll talk a little bit about the decision and then the impact. So, as many, I assume most know that that the Clean Water Act is our fundamental water pollution law that keeps pollution out of our rivers, lakes, streams, and other really important waterways. It was passed with bipartisan support in 1972, and it's been a success. But, in the majority opinion in Sackett, Justice Alito acknowledged that success, writing for the majority, but then he proceeded to undo, decades of half a century of progress under the Act. So quickly, the Clean Water Act prohibits the discharge of pollutants or the dredge and fill of navigable waters, which Congress defined as waters of the United States. Since the Clean Water Act permit programs and other protections apply only to waters of the United States, how that term is defined is critically important to water quality. The sole objective of the Clean Water Act is clear. It's in the first section of the Act, Section 101, and it is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. And aside from a short time under the prior presidential administration, the current waters of the United States has been given a broad science-based reading that based on the understanding that waters are connected in various ways through the aquatic ecosystem, through chemical, physical, and biological connections. In 2006, the Supreme Court revisited the definition of waters of the United States after the Supreme Court had long applied this science-based definition of waters of the United States. And in 2006, the case Rapanos versus United States, the court issued a fractured decision where it was 4-1-4. We did not get a majority opinion telling us how waters of the United States should be defined. Justice Scalia, writing for the plurality, would have limited waters of the United States to relatively permanent waters that have a continuous surface connection to traditional navigable waters, our big lakes and rivers and oceans. Justice Kennedy, concurring in the judgment, followed Supreme Court practice, decades of agency, Supreme Court decisions and agency practice in adopting what's known as the significant nexus test. And Justice Stevens and 3 other justices in the dissent would have deferred to the agency's finding that waters that meet either Justice Scalia's or Justice Kennedy's test are waters of the United States. And the Sackett EPA case is the first time since Rapanos that the court has weighed in on the definition of waters of the United States. So Sackett, short summary of facts, a couple in Idaho wanted to build on their land a stone's throw from Priest Lake. And on their land, there were wetlands that were part of a larger wetland complex. And their property was 300 feet from Priest Lake, a traditional navigable water, and 30 feet from an unnamed tributary that connected through subsurface flow to another tributary and eventually flowed into Priest Lake. In 2007, the Sackett's, preparing to build on their property, began grading it and filling it filling the wetlands with sand and gravel without a Clean Water Act permit. And EPA issued a compliance order telling them to remove the fill and to restore the wetlands. According to EPA at the time, wetlands were waters of the United States under the significant nexus test as articulated by Justice Kennedy in Rapanos. The Sackett challenged that order, and the district court upheld the EPA's finding of jurisdiction under the significant nexus test, and the Ninth Circuit affirmed. One unusual thing about this case is that the court granted cert at all, because for a number of reasons. Number one, there was no circuit split. Every court of appeals to consider the scope of waters of the United States had determined that waters that meet Justice Kennedy's test are waters of the United States. So no circuit split. 2, EPA had withdrawn the compliance order. So there was no risk of renewed agency enforcement. The Sacketts were allowed to proceed with their building on their property without concern for violations. So for a practical standpoint, there was nothing left in controversy. And then finally, the Biden administration was well on its way in adopting its own definition of waters of the United States. And when that happens, the hope is that the Supreme Court would wait and defer to the agency and evaluate the agency's rule on the record. They didn't do any of those things. They could have waited or punted, but they wanted to weigh in on this issue. We at the Southern Environmental Law Center submitted an amicus brief on behalf of 114 environmental and community organizations, urging the court to side with the EPA and endorse the significant nexus test that we had seen through the court's prior decisions. The court did not do that. So Justice Alito wrote for the majority. He was joined by the Chief Justice, Justices Barrett, Gorsuch, and Thomas, and they adopted Justice Scalia's test from the Rapanos decision. Justice Thomas wrote a concurrence that was joined by Justice Gorsuch, in which he would have gone even further in limiting the Clean Water Act and in limiting government authority under the Commerce Clause. Justices Kavanaugh and Kagan wrote separate concurring opinions that were joined by Justices Sotomayor and Justice Jackson, in which they criticized the majority for redefining the word adjacent that had been used throughout the court's decision and for rewriting the Clean Water Act. There were no dissents in the case, which was surprising, but all of the 9 judges agreed that EPA could not require the SACIT to get a permit for the wetlands on their property because those wetlands were not waters of the United States. And the court could have stopped there. They could have limited their decision to the facts, but they went way further. The justices agreed on the test that should be applied when defining waters of the United States. So I'm just quickly going to go through the majority. And in endorsing Justice Scalia's test, Justice Alito also endorsed his reliance on the dictionary definition of waters, holding that the term waters of the United States includes only those relatively permanent waters forming geographic formations that are described in the ordinary parlance as streams, oceans, rivers, and lakes. That's the dictionary definition that Justice Scalia relied on as well. This decision has Scalia's fingerprint all over it. Then on the wetlands question in particular, the majority agreed that some adjacent wetlands are covered, but here, while they followed the dictionary definition of waters, they ignored the definition of adjacent in the dictionary. Justice Alito acknowledged that adjacent is defined as next to and not conjoined, but he said, I don't have to listen to that, and really redefined adjacent to mean abutting. So according to the majority, the only wetlands covered by the Clean Water Act are those which have a continuous surface connection with a relatively permanent body of water that is connected to a traditional navigable water, like a river, stream, a river, ocean, making it indistinguishable such that it is difficult to determine where the water ends and the wetland begins. So the majority opinion significantly reduces the scope of the Clean Water Act. Some estimates are that half the nation's wetlands will lose protection, upwards of 118 million acres of wetlands. So this is a really big deal for water quality and for families and communities, because wetlands filter out pollution before it reaches our drinking water sources. They act as natural sponges, holding back floodwaters. They sustain our fisheries, and they provide really important habitat for species. And by not protecting the vast amount of waters now excluded from the act, the court majority jeopardizes the health of the rivers, lakes, oceans, and other waters that do meet the court narrow test, because those waters rely on the health of the waters that are connected to them in various ways or otherwise affect their health. So what's really shocking to me is that the majority opinion did not discuss the Clean Water Act's objective of restoring and maintaining water quality. And worse, it makes it impossible to meet that objective. So that is the drastic effect on the Clean Water Act. And there were other aspects of the decision that will have far-reaching results beyond the Clean Water Act. And in the majority opinion, in addition to the water quality impacts, the majority places limits on the federal government's ability to protect public health and the environment. And these limits, like I said, will extend far beyond the Clean Water Act. So building on the West Virginia v. EPA case that we heard about a few minutes ago and the major questions doctrine, the court added a clear statement rule that must be applied to congressional grants of authority to agencies in 2 additional circumstances. 1, where there are potential for criminal penalties, and 2, where there is an imposition on private property. Justice Alito emphasized it would be difficult, if not impossible, for many landowners to determine whether the Clean Water Act would apply to their property, which he viewed unacceptable given that landowners could face penalties for violations of the Act. Therefore, to avoid vagueness concerns, the presumption is that they applied the presumption that ambiguous provisions will be read in the defendant's favor. This is a real signal that the court has disdain for the administrative state. They do not want to defer to agencies. It's another signal that Chevron deference is on the chopping block. Indeed, the court will consider that issue next term in the Loper Bright Enterprises case, and eliminating that doctrine will shift more power to the courts and diminish agencies' ability to issue durable regulations that are in the public interest.
Thank you so much, Kelly. I think that's a great part to move on. For better or worse, I think the common thread there between both sort of the look at all of the cases of federal power was that as extreme as some of these decisions were this term, there are like not even hypothetical, but actual cases either already on the docket or almost certain to come before the court next term that will almost certainly go even further in expanding the court's power at the risk of minimizing executive and administrative power. So thanks so much for that real good look at some of the key cases addressing sort of federal, statutory, and constitutional power. Next, I want to look at a series of cases that really talked about sort of state and federal interplay. And the first one to talk with Winona Single, the Associate Professor of Law at Michigan State University College of Law, is going to talk with us about the somewhat, maybe not, we'll hear her take on the decision in the case over the future and past and history of the Indian Child Welfare Act. Welcome, Winona, glad to have you today.
Thank you so much. It's an honor to be here. Yeah, so the case of Holland versus Brackeen, which involved multiple constitutional challenges to the Indian Child Welfare Act, is really a huge surprise for everyone in the field of federal Indian law. It's sort of a bright spot in this term in the sense that we had anticipated that the Supreme Court could completely shatter the foundation of federal Indian law with a far-reaching decision limiting Congress's constitutional authority in Indian affairs in this case. So that did not happen, and so there was huge cause for celebration for advocates of IDQA, but also just across the board in Indian affairs. And so first I'd like to give you, everyone listening, a little bit of an intro to the Indian Child Welfare Act. The statute was passed by Congress in 1978 out of recognition that there was a long history of widespread, unwarranted, lacking due process removals of Indian children from their families in the United States. And there were studies that had shown that somewhere between 1/4 to 1/3 of all Indian children were being removed from their homes prior to passage of the statute. That includes my own younger sister, my mother, and 4 of her siblings. And that in 90% of the cases, these children were being placed with non-Indian families. And so it absolutely was a violation of the due process rights of children and their families. And it also threatened the very continued existence of Indian tribes in the United States themselves. And these, in many cases, the both private and public agencies involved in these child removal cases were often motivated by stereotypes, anti-Indian sentiment, and made clear statements that they did not believe children should be allowed to grow up on the reservation. And so the ICWA was passed by Congress to provide procedural and substantive protections that would put a stop to these unwarranted removals. And so there's a variety of protections. Some of the more notable ones include that, for example, if a child's domiciled on the reservation, the tribe has exclusive jurisdiction. And even if they're domiciled off the reservation, there can be a transfer of jurisdiction when a tribe requests. Also, the statute applies to an Indian child who's either a child enrolled in a tribe, who's a member, or who is eligible for enrollment and has a biological parent who is enrolled. And in addition, the statute provides for what are called placement preferences. And so there's 3 principal placement preferences that we typically refer to, which are that if you have an Indian child, for example, that is to be placed in an involuntary custody proceeding. First, they must be placed with someone from the child's extended family. Second, the placement preference requires that they be placed with someone from the child's tribe. And third, the placement preference requires they be placed with another Indian family, which could be a family from another tribe. And so there's a lot of sentiment among some non-Indian couples that seek to adopt Native children that they're being discriminated against, and that their rights are not being protected, and they're not playing on an equal playing field with the other families that receive the benefits of the placement preferences. So there's also notice requirements, record keeping requirements, and there's also the gold standard of with principle of the Indian Child Welfare Act really comes in part from a requirement that active efforts must be applied to require to support the rehabilitation and to restore the Indian family. And only if those active efforts have been unsuccessful is a child, then removed and or rights terminated of the parents. And so there's a number of these protections in place. And so for a long time, for many years now, we've had coordinated attacks on ICWA across the United States. And in many cases, they've been coordinated with the assistance of the Goldwater Institute. And in a lot of ways, it's been like just throwing anything against the wall to see what would stick. And in this case, 3 adoptive couples, non-Indian adoptive couples, and a biological parent of an Indian child, they brought a claim, and along with the state of Texas, Indiana, and Louisiana, in the Northern District of Texas, before the famous Judge Reed O'Connor, who, as you know, had determined that the Affordable Care Act was unconstitutional, and so he immediately, quickly determined that, sided with the states and the adoptive couples. And in addition, several tribes had also intervened. And so ultimately, the case is appealed to the Fifth Circuit, where a divided panel affirms the constitutionality of the statute, but then there's en banc review is sought and obtained. And in that en banc decision that's ultimately produced, it's over 325 pages long. It's incredibly long, and there's an incredible diversity of opinions reflected in that case. In that opinion. And then ultimately it's appealed to the US Supreme Court and was argued last November 9th. And so Texas is the only state to participate in the appeal before the Supreme Court. And then you also had several tribes, Cherokee Nation, Navajo Nation, the Morongo Band, and the Quinault Nation. And you had the adoptive couples as well. And so what's really remarkable about this is that the case was a 7-2 decision authored by Justice Amy Coney Barrett. And of course, Amy Coney Barrett, along with Justice Roberts and Justice Thomas, is an adoptive parent. So we were a little concerned about how adoptive parents might view the Indian Child Welfare Act's protections. But the majority opinion authored by Justice Barrett, which was joined by Justice Roberts, Sotomayor, Justice Kagan, Justice Gorsuch, Justice Jackson, it strongly affirmed Congress's constitutional authority in Indian affairs to pass the Indian Child Welfare Act. But in doing so, there's really a very strong opinion that supports existing precedent regarding Congress's plenary authority, which is not unlimited, but which exists in Indian affairs. And so when in looking to the U.S. Constitution's language for that authority, the court first points, of course, to the Commerce Clause. And so as we know, the Commerce Clause in Indian affairs is not read in an identical fashion as the Commerce Clause with respect to commerce with foreign nations, among the several states, and with the Indian tribes. And so the majority opinion clearly recognizes that there are very strong precedents which establish that commerce that Congress has the power to regulate with Indian tribes, it's a plenary power, and that it includes Indian affairs, broadly speaking. It's not just related to trade, for example. And so it is a broad source of authority. And then in addition, the court looked to the fact that there's the treaty clause, and that also the treaty clause does give Congress the power to enact legislation that furthers treaties entered into. And then in addition, there's also the fact that we have pre-constitutional powers that are recognized as being incorporated, if you will, into the Constitution, and that these are powers that are consistent with the powers that are necessary concomitants of nationality, and they relate to powers in Indian affairs, not just the power to wage war and peace, but even the authority to establish a Department of Indian Affairs, for example, and to administer Indian affairs. And then also there's the trust responsibility in Indian affairs as well that the court referred to. So this overall is an incredibly strong affirmation, because not only does it protect the constitutional authority of Congress to pass the Indian Child Welfare Act, but we were concerned about the potential of a limiting opinion in this regard, which would invite other litigants to challenge criminal statutes in Indian affairs and other statutes on the basis that they're beyond Congress's authority. And so the court really strongly affirmed Congress's constitutional authority in Indian affairs. And then in addition, in another argument that the court reached on the merits in its majority opinion, there were arguments made by the petitioners, the state of Texas, and the petitioners that related to the anti-commandeering doctrine. And so there was an argument that various provisions of the Indian Child Welfare Act, which require, for example, active efforts, and that require also the application of placement preferences by state courts, and that require also certain record-keeping functions of state courts. The petitioners had argued that those provisions violated the 10th Amendment. And so the Supreme Court issued an important decision for anti-commandeering doctrine generally, which also has significance beyond Indian affairs, and ultimately held that, for example, when a statute is equally applicable to private parties as well as state parties, such as the active efforts requirement of ICWA, that generally it's deemed to be permissible and not a violation of the anti-commandeering doctrine, and active efforts in the statute was applicable to private agencies as well as state actors. But then also the other provisions of ICWA, the placement preferences, they're applied by state courts. And so clearly the anti-commandeering doctrine applies and is triggered when the federal government, Congress attempts to impose mandates on state officials in the executive or legislative branch, but not in the judiciary branch. And clearly under the supremacy clause of the Constitution, state judges, state courts must comply with federal law. And so the placement preferences are do not violate anti-commandeering because of that supremacy clause. And then in addition, the court also found that with regard to record keeping requirements, those are considered ancillary to state court adjudication of ICWA cases. And so the court said, we have plenty of precedents that already established that where a state court can also be required to comply with federal record keeping requirements and not just apply federal rules of decision. And so that's ancillary to the authority that the requirement that state courts must comply with federal law. And so the court did not agree then with the anti-commandeering arguments that were raised as challenges to the statute. And then in addition to that, there were two other arguments that were made. One was a very significant argument that ICWA violates equal protection of the U.S. Constitution. And the court in the majority decision did not reach the equal protection argument on the merits because it determined that the state of Texas and the adoptive couples lacked standing to raise that. And also there's another argument, which was more of a nothing burger in the relative scheme of things, which was a non-delegation argument. And the court also did not reach that argument on the basis of lack of standing as well. And so more specifically, the court found that the adoptive couples, they had where the initial case had sought to obtain to enjoin the federal Secretary of Interior, the federal government, including Secretary of Interior and Secretary of Health and Human Services, but did not name any state parties, that there was no redressability because it's state parties that apply and attempt to enforce the Indian Child Welfare Act, not the federal government. And then in addition to that, with regard to Texas's arguments that ICWA violated equal protection, the court concluded that Texas does not have equal protection interests. And so it also lacks standing. So, so the court doesn't reach that. And there are folks who remain concerned that perhaps in the future, the court will accept a case on appeal where there is standing by the parties and where equal protection is squarely presented. And in footnote 10 of the majority decision, the court notes that there's a case involving one of the adoptive couples. It's one of the parties to this case. They're seeking to adopt a child in a case called YRJ. In state court, and Matt McGill from Gibson Dunn, who was one of the oralists in this Brackeen case, is representing those couples, and that couple is certainly bringing an equal protection claim. And so,
I'm sorry. Yeah,
I speak too long. I'm so sorry.
No, it's fine. I wrote about this case and spent all day on it. I mean, it truly does go to show how in the past, this throw everything at the wall theory might have resulted in a dismissal, but now it ends up with cert being granted, an entire decision that goes on about all of these issues, and they still leave the door open to a potential future case, which some of the justices basically said that they want that case. So we almost certainly are going to get those cert applications, if not grants. So thank you so much. On the other big state and federal interplay issue, we've got Ruben Garcia here to talk about, professor of law and co-director of the Workplace Law Program at the University of Nevada, Las Vegas, William Boyd School of Law. First going to talk about the National Labor Relations Act, its history, its future, and Glacier Northwest.
Thanks very much. It's great to be here with this excellent group, and I am in the unenviable position of talking about 3 cases from last term in 10 minutes. I know we have a lot more to talk about and a lot more discussion to have. So I'm going to go quickly through these 3 cases, which I think all can be united by a few single threads, and that's not a plug for anything. But it is clear that these 3 cases are united by their suspicion of administrative agencies and suspicion of government. So this is par for the course for the conservative legal movement, but it is, of course, within 3 different statutory
Just
key
so
and
that-
constitutional schemes.
So that people who haven't seen our preview know, the other 2 cases that you're going to be talking about are 303 Creative and Groff versus DeJoy.
Right. So I'll start, as you said, Chris, with the Teamsters case. And again, that's under the National Labor Relations Act. Once again, an example of a unbroken string of defeats in the Supreme Court when unions are a party. It includes cases that you may be familiar with, others may be familiar with, like Janus versus AFSCME, Cedar Point Nursery versus Hasid, recent cases in the Supreme Court. But this is a case involving the National Labor Relations Act and preemption of state law claims under the NLRA. And the NLRA, as folks may know, was passed in 1935 and intended, of course, to put most of these labor disputes, unfair labor practice charges, negotiations, breaking down strikes within the exclusive jurisdiction of the National Labor Relations Board. And so when negotiations broke down between Glacier Northwest and Teamsters Local 174, which involved ready mixed concrete to businesses in King County, and the truck drivers went on strike in 2017. There was a threat to the trucks and cement of the employer, and the employer, as the opinion notes, scrambled to make sure that there was no damage to the trucks in this dispute, but they lost some of their concrete as a result. So Glacier sued in state court, a variety of court claims alleging that the Teamsters and the union members' strike resulted in damages to them. As with most disputes or most state court claims arising out of a strike, the trial court dismissed the claims under something called garment preemption, which is relating to a 1959 Supreme Court case. And it is when any conduct coming out of a labor dispute, is either arguably protected or arguably prohibited by the National Labor Relations Act. And so the trial court dismissed the case. The Washington State Supreme Court dismissed the case on the preemption grounds that the Supreme Court has adhered to for many, many years. So, of course, the court takes the case, and it is a 8-1 decision where 8 justices believe that there is a possibility that, again, we're talking about a preliminary stage, the motion to dismiss stage, the allegations are deemed as true. There are cases involving unions engaged in strike misconduct that could be adjudicated by the National Labor Relations Board and may result in unfair labor practices against the unions. But this case, arguably, as you know, the meaning of arguably, of course, is the key to this, is about whether or not the employees intentionally meant to damage the trucks or the concrete of the employer, and that would, of course, may lead to, in this under their theory, state court liability. Of course, the other side of it is the employees, as unions do, look for the most opportune time to strike and to engage in economic action to increase their leverage. And so many National Labor Relations Board cases have upheld the employees being able to walk out when it's the right time for their maximum leverage. So the 8 justices joined the opinion that the case should be sent back to Washington courts to determine whether there was an intent by the union to damage the employer's property and how that might lead to the tort liability. Garment preemption survives, and of course, many theories about why it's 8-1, and an opinion authored by Justice Amy Coney Barrett and joined by 7 other justices, including Justice Kagan and Justice Sotomayor, is the idea that garment preemption may not have held if there was not that unified opinion by 8 justices. So that is the outcome of the case, but the very important dissent and a very vigorous sort of affirmation of the administrative state and the role of the National Labor Relations Board in adjudicating labor disputes just like this one is authored by Justice Ketanji Brown Jackson. And it is, again, going to really what the case is threatening to do in her dissent. As she says, if the misapplication of garment preemption in this case threatens to both impede the board's uniform development of labor law and erode the right to strike. And that is, again, what is everyone is concerned about in the future about the labor movement's strength and the strength that we've seen in a number of areas recently in Amazon and Starbucks, maybe being threatened by litigation by employers to blunt the right to strike and the momentum of many of these organizing drives. Of course, I could talk in Q&A or elsewhere about the other side of this, which is if garment preemption or the exclusive jurisdiction of the NLRB goes away, are there tactics that unions can engage in state court that may be increase their leverage, just as employers might possibly use state court litigation to increase their leverage in labor disputes? So we'll have to wait and see on that one. The next case I've been asked to talk about is one that's maybe familiar to more of you in this call, and that is 303 Creative versus Linux. And that, of course, is the case involving the Lori Smith, the Colorado web designer, who alleged that she was concerned and that she had a credible threat of enforcement, that she would be required to open her business designing websites to gay wedding websites. And so she's also averred that she opposes same-sex marriage on religious grounds and does not want to design these websites. She does not want to post the required message that the Colorado Commission for Civil Rights requires, that there should be no discrimination in businesses like hers that are available and open to the public, so-called public accommodations. And so the Colorado Commission on Civil Rights basically is enforcing the Colorado Anti-Discrimination Act, which prohibits businesses from discriminating on bases, including sexual orientation. So this case, of course, because of the prior cases, prior precedents that, as Justice Sotomayor in her dissent says, are throughout the court's history, it's never granted a business a license to the public as a constitutional right to refuse to serve members of a protected class. And so she has, the case goes through the 10th Circuit and is teed up at the Supreme Court, where it falls much more predictably along a 6-3 axis with Justice Gorsuch writing the opinion, upholding, and really an opinion, again, that focuses less on her religious beliefs, but rather her First Amendment compelled speech right. And again, as Justice Gorsuch argues, there is a lot of precedent for the right of these kinds of rights in the court's cases, including Hurley and Roberts versus JC's. But these are cases, as the dissent goes through, that are really different than this case because they involve, of course, associations, right? Not businesses open to the public, right? And so the just a few terms ago, we were all talking about what is the sort of logical extension or the outer boundary of Masterpiece Cake Shop versus Colorado Civil Rights Commission. They're very busy. They're very often in the Supreme Court, aren't they? And they, where the court said, as Justice Sotomayor said in her dissent, the court said, we do not believe that religious and philosophical objections to gay marriage should allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law. Well, again, the difference here, according to Justice Gorsuch and the holding, basically, is that this is an artistic expression that can't be compelled in the same way that you can't compel any artist to draw a painting of any particular thing or any kind of artistic expression. And so, of course, the next cue is going to be about how broad that artistic expression license is going to be in all kinds of businesses that are open to the public. And that is, of course, another example of the thread here, which is, again, a suspicion of state agencies and the ability to enforce generally applicable rules, just as the NLRB was, not allowed to basically enforce unfair labor practice charges. They have, of course, now the Colorado Civil Rights Commission have another kind of exception to their jurisdiction. So, and of course, as Steve and others have pointed out, there are all kinds of standing problems with this particular court, in terms of their application of standing law. And this is another example, maybe another example of that problem that we'll see coming up in other cases. I know there was also a question about the interaction between this case and the upcoming content moderation cases that Steve talked about. I think, again, that the breadth of that exception for artistic license sort of in designing websites, I think is the main kind of thread, to use the term, that may be part of a lot of these cases coming up regarding the internet and web design. So we'll just have to see how that plays out.
And
the final
Groff versus DeJoy, can you just give us sort of like a quick summary of sort of like
sure
why it matters, how it fits into the term's bigger picture?
Sure. Well, again, the thread is an administrative agency or a federal statute like Title VII of the Civil Rights Act, which prohibits religious discrimination, but allows for to generally applicable rules of an employer, reasonable accommodations for religious practice. And basically, an employee of the U.S. Postal Service, and again, here's maybe suspicion of the U.S. Postal Service or federal government, basically comes through in terms of not really accepting their argument that the accommodation for the plaintiff in this case, Mr. Groff, was an undue hardship, right? So actually, in this case, 8-1 with one, unanimous on the result, but with one concurrence, the court basically clarifies the undue hardship standard and says that it has to be involved in a substantial extent to the employer to basically say that it's an undue hardship to accommodate the employee's religious exemption. So that, again, the upshot of all that, I think, is generally, what we've seen in past cases, which is kind of a suspicion of the administrative state of the New Deal. And I've written about that elsewhere. And so I'm happy to talk about that more in Q&A.
Thanks a lot. Last but not least, Debo Adegbile, partner and chair of the anti-discrimination practice at WilmerHale. WilmerHale, you are here to talk with us about some of the big cases that where the court sort of swung from both directions of avoiding some of the largest concerns of the term, and also just followed through on exactly the large concerns that we thought. And that's the cases of Moore versus Harper and Allen versus Milligan, the independent state legislature clause, and the Voting Rights Act. And then following up with concluding our discussion of the cases with the two big affirmative action cases. Debo?
Great. Thanks so much. It's good to be with you. I've enjoyed hearing from my colleagues about the other cases during the term. And forgive me for the sounds of New York City in the background, which is part of the melody as I conduct my lawyering through the years. So here I'll start with the voting cases, and I was fortunate to file briefs in all three of these cases, in one case representing a party and two other cases as an amicus on behalf of my client. But today I'm speaking to you in my personal capacity and not about any of those representations. So starting with the Milligan case. The Milligan case is a case that presented a question about the reach and scope of the Voting Rights Act, Section 2 of the Voting Rights Act in particular. The Roberts Court has been very active in its Voting Rights Act jurisprudence in mostly ways that are inconsistent with the congressional purposes and goals of the Voting Rights Act. And there were a lot of fears that this case, that the Milligan case, which involves Alabama's congressional districts, would continue that trend. The Supreme Court decided 10 years ago, in an opinion by the chief, the Shelby County case, and that was a case that struck down a core provision of the Voting Rights Act, the preclearance provision of the Voting Rights Act. And part of the rationale backstopping the striking of that provision was this idea that we didn't need to be so worried about this provision that focused only on some parts of the country, because we had this nationwide Section 2 provision that could protect minority voting rights in all the instances where it needed to be protected. So it was with some alarm that those of us who are in the voting bar were of the Supreme, first a stay actually of a ruling, a preliminary injunction ruling by a district court panel in Alabama that I think contained two Trump appointees, finding that the map drawn by the Alabama legislature, that there was a likelihood of success on the merits, that it diluted minority voting rights. That is to say that by having only one Black minority majority district in Alabama, despite a very substantial Black population, it was weakening the strength of minority voters in Alabama. And so that lower court found that it wasn't that close a case under the Voting Rights Act, under Section 2 of the Voting Rights Act. Nevertheless, the Supreme Court stayed the preliminary injunction. They said that ruling of the lower court, that this map dilutes, that is, undermines the voting power of Black voters, that holding will not take effect. And essentially that allowed that map to go forward and elections to be conducted under that map. Once that happened, we worried that the court was going to constrict the precedent under Section 2 of the Voting Rights Act. And that was the question that we were facing in Moore. What is the reach of the Jingles precedent, the precedent that set out how you look at redistricting, how you measure vote dilution in a redistricting context? And Jingles had what were sort of three prerequisites, three things that plaintiffs need to show. We don't need to go deep into the weeds, but I'll just very quickly say that the first showing that plaintiffs make in a Section 2 case is to show that the minority population is sufficiently numerous and compact that you could draw a minority majority district under some notional map, some map that you proffer, and show that it's possible to do that, where you're arguing that the votes are being diluted. The next is that the minority community votes cohesively. That is, that it's not a very fractious populace, that they're tending to vote together. So if you were to draw a district, it could have some electoral power consequences, is the idea. The last is that there is sufficient, a high degree of racially polarized voting. That is, that the white majority consistently votes to defeat minority preferred candidates. And these are the threshold showings that you have to make. In this case, the state was arguing that first prerequisite, that's showing that the minority community is sufficiently numerous to draw a compact single-member district, that showing needs to be considered through a race-neutral lens. Essentially, divorce yourself from the exercise of what redistricting is, to look at people, to look at where they live, and to put the lines around them, understanding neighborhoods, and we have great data about where people are. Essentially, the state was advancing that there is some notional Oz in which you can draw maps that don't have any consequences with respect to race, and is the better way to go. Essentially undermining what really is the core purpose of the Voting Rights Act, which is to consider where minority voters are being adversely affected by electoral rules. And ultimately, once the court decided to hear the case, we were scared that the court might take up that notion, which would really twist Section 2 up in the way that the court had done violence to the preclearance provision of the Voting Rights Act in Shelby County. Surprisingly, and it shocked me, I think I was predicting perhaps a negative outcome when the decision hit my computer, and the Chief Justice who wrote the Shelby County opinion essentially upheld and sort of vigorously leaned into the earlier Jingles precedent, acknowledging that the standard reading of the Voting Rights Act under Jingles is one that is supported by deep precedent, that it is a bounded standard, that it is one that is exacting, I think was the word of the Chief Justice, and that it operates in situations where there is packing or cracking, dilution of minority votes. And it was a surprisingly robust vindication of the underlying precedent in that case. Kavanaugh joined that opinion of the Chief Justice, and he concurred. And he actually sent some signals that would portend some things that I'm going to talk about in a little while. Among other things, he was sort of focused that the precedent mattered, that we should follow precedent here, that there was no proportional representation that the Section 2 is directed at, but it's directed at specific efforts to respond to vote dilution by packing or cracking, separating minority voters so they can't have voting power, or over concentrating on packing so that they have less voting power than they would if reasonably distributed. And that opinion of Kavanaugh was important, but he dropped the breadcrumbs here. He said that one of the things that had not been raised in this case was any question about a temporal limit of Section 2 of the Voting Rights Act. The idea that because Section 2 is a measure that is race conscious, there was no claim in this case that there was an expiration date, in a sense, pointing toward a future perhaps constitutional challenge for Section 2 of the Voting Rights Act. The case was very ably argued by the LDF's Duell Ross, and it was an important victory for the Voting Rights Act and for fairness in elections. But what we know in Voting Rights Act litigation is that the battles are never done, and already there are people invoking the precedent in that case, the concurrences, and the opinion in a decision that I will speak about shortly, to try and introduce the concept of new constitutional challenges in active litigation in Louisiana. So we need to watch out for these cases. What
happened in Moore versus Harper?
Yes, moving very quickly to Moore v. Harper. This was the case that I think also sent a little bit of a heart palpitation to those of us who care about American democracy. Why, you may ask? The reason is that the Supreme Court some years ago in a case called Rucho essentially said that partisan gerrymandering, that is where legislatures are really focused on extracting maximum partisan advantage after the decennial census when they redraw districting lines, that those efforts to advantage Republicans disproportionate to the distribution of the partisan makeup, or in the other case, Democrats doing the same thing. Both parties can manipulate the redistricting process in this way, that those partisan manipulations of the districting map are not cognizable as a matter of U.S. constitutional law in Rucho. That was very concerning to everybody. But the reason that this next case, Moore v. Harper, was so important is that they're still state constitutions. And the state, under a state constitutional theory, the map drawn in North Carolina was challenged as a grotesque partisan gerrymander in North Carolina. that in a very lopsided way drew districts that favored the Republican party in a way that really limited dramatically the opportunity of Democrats to elect candidates of their choosing in the map. And ultimately, the court found that that was a problem, and a remedial map was drawn, and elections proceeded under the remedial map. The case went to the Supreme Court because the Republican legislators that had drawn that map, they argued that there was a sort of what we call the independent state legislature theory. That is that the elections clause, Article 1, Section 4. Is it Section 4 or 5? It's escaping me right now. But the four. I'm trying to read the fingers. Yeah, Article 1, Section 4 of the Constitution. Good to have the con law professors with me. Essentially gives sole responsibility for drawing redistricting maps to state legislatures, not state courts. The idea being that they wanted to wall off state courts from having any role in interpreting state constitutions in assessing maps, because the power under this sort of broad sweeping theory was that the legislature controls the whole thing and gets to dictate the outcome. When you put that theory together with the earlier case Rucho that says that the federal constitution is not going to reach these things, we can imagine what that would mean for American democracy. It would lead the barbarians at the gate of partisan manipulation to essentially have no limit to what they could do. And so the concern in this case was that the court would give some life to this theory, but in an opinion by the Chief Justice, the court essentially rejected the major premises of this theory, said that the independent state legislature theory is not consistent with earlier precedent and with the state courts having some role in interpreting these redistricting maps under the theory that the Supreme Court has not adopted. And they saved some space there. They did sort of put in some ominous language about how state courts essentially need to behave themselves and not arrogate to themselves a sweeping power that will play out in future cases. And we'll have to see what the boundary is between the Supreme Court's idea of where state courts are leaning into this issue too far and stepping into what the court has called the political thicket too deeply. But an important ruling that didn't take on the worst concern or the most deep concern about undermining democracy. Moving to a case that does.
One second.
Yeah.
I just want to, before we get onto the affirmative action cases, I want to, for the CLE people, want to let you know that your second word is fireworks. As in the 4th of July fireworks and the end of Supreme Court term fireworks. And I also know that Steve Vladeck is going to have to leave us for his next event. And so thank you so much for joining us, Steve. And now if you can talk with us about sort of one of the three end of term 6-3 fireworks from the conservative majority.
Absolutely. And fireworks indeed is an appropriate word. So in the Harvard and UNC cases, SFFA versus Harvard and UNC, these were challenges about a private and separately a state institution's ability to consider race as one of several factors in admissions decisions. Following a long line of precedent stemming back to the 1970s, the Bakke case at the University of California, some of you may recall, all the way through the Michigan cases, the Grutter and Gratz cases, and then most recently the Fisher cases that hopscotch up and down to the Supreme Court 2 times. There's been, for over 40 years, there's been a line of cases that said that there is a compelling governmental interest that colleges and universities can pursue in considering the diversity of their admits, of their cohorts as they're admitting students, provided that there are some guideposts in place and that race isn't playing too great a role, that the colleges aren't pursuing quotas, and that the analysis is narrowly tailored and that colleges consider, for example, race neutral options before employing race. And so in these cases, the reason fireworks is so important is because the court said that compelling governmental interest, they treated it as foreign and weak and something that was not susceptible to the strict scrutiny analysis, which applies to race-conscious decision-making. They said that it was too difficult to measure, that it was not time limited, and that it was very difficult for the court to apply the requisite level of constitutional analysis to this rationale. Ultimately, they held that the consideration of race on the strength of that advanced rationale, the core rationale being that colleges can seek to consider race as one of several factors in a holistic admissions process in service of having a diverse cohort of students, because there are educational benefits that flow from in residential college learning environments, from having racial diversity among other types of diversity in the learning environment. That rationale, which is well supported by educational literature, was found to be too mushy for the Supreme Court. They acted as if Harvard and UNC had made it up anew for the first time, had spontaneously generated it for purposes of this litigation, when in fact it had been recognized by the court in many different precedents. The court also said that the practices of Harvard and UNC fail to comply with the twin commands of equal protection, that race may never be used as a negative factor, and that it doesn't operate as a stereotype, suggesting that that considering race as a positive factor in the candidacy of one student is inherently a negative factor for other students in the pool. The Chief Justice used the expression zero sum, that college admissions is a zero sum game. There are winners and losers, and every factor that's considered in support of one student is inherently a negative factor for other students. This was a big fireworks decision in a dissent by Sonia Sotomayor. She took the court to task for breaking with precedent. She explained that the interpretation of the 14th Amendment was not well placed. She talked about the practical implications of this ruling, and she suggested, as did Justice Thomas in his own opinion, that what the court had done here is not just set aside lower court rulings, finding that there had been a violation of equal protection and Title VI, which applies to private institutions and institutions, private and public institutions that receive federal assistance, but also that the court had in effect gutted the precedent. The idea being that the court did not say we overrule that line of precedent I mentioned, but in effect, both from the right and from the progressive side, there are justices saying, in effect, what you have done in this opinion is to overrule the precedent, but just not own that that's what you're doing. There are a number of impacts about this decision. I'll just very quickly suggest some of the things that we need to be thinking about. There is a through line in this conversation in the last several terms about how this court regards or disregards precedent. I've just spoken to that a little bit. There are so many cases. The court here really they acted as if that they were acting, that the ruling was consistent with precedent, but it's hard to sort of line it up with the precedent as we've understand it, what's been recognized. The other thing that we look for in many cases, particularly in the racial justice cases, is whether the court pays any heed whatsoever to the findings of the lower court and the record. And what we saw in this case, as in so many cases, is that the court is untethered to the record below and starts to sort of imagine its version of what's happening in this case in college admissions offices, and doesn't trouble itself to really drill down on the actual findings of the case, all of which went in favor of the universities in this case, and the court didn't really grapple with them in a significant way. And I'll say that this is, in a sense, a way in which the Chief Justice has accomplished something that we know that he's been thinking about for a long time. In a voluntary K through 12 education case, parents involved, the Chief Justice said the way to stop discriminating based on race is to stop discriminating based on race. Essentially, removing race from the equation is the only way to end discrimination, rather than taking account of discrimination and thinking about how our laws address it in a meaningful and responsible way. He said in a voting case some years ago, the LULAC case, that isn't this a sordid business, this divvying us up by race? There were elements of both of those strains of thinking in the Chief Justice's opinion that has now been elevated to a majority opinion of the Supreme Court in the admissions cases. And finally, I'll say we look forward to what's going to happen here. And what we know is that in the real world, we have states that under state constitutional amendment through ballot initiatives have barred the consideration of race in admissions. We have that in a number of states. And what we have seen is that there has been a diminution in both the applicants and the admits, particularly of Black students, but we've seen it with some other racial minority groups. The data is complicated in some instances because population trends can sometimes overcome initial deficits, for example, in the Latinx community. But what we have seen is that it has an impact in the diversity that we see in higher ed. And what we fear is that it will have an impact here. These are important cases, both because of what they mean here and because they signal how the court thinks about race and the journey that the nation is on to lift up our civil rights laws and our laws that are about making the democracy a meaningful one for each and every one of us.
Thank you so much. Thank you to everybody, all of our panelists, Debo, Kelly, Winona, Ruben, and Steve. I really appreciate all of the key information that you gave us, both about the cases, the implications, and obviously, I think important for everybody to note that pretty much everybody's addressing of their cases talked about what cases are going to be coming in the future, and what cases are already being filed or addressed, how these opinions are being used in lower court rulings and in ongoing trials and cases. And so I think that sort of the bottom line for this term is that this new 6-3 majority is continuing to address the most extreme positions brought to it by either agreeing or sort of putting it off to a potential future case, but rarely dismissing it in full. I think maybe one of the only cases where they did dismiss it sort of in full was the independent state legislature case, but even there, as Debo said, they sort of did give us a secondary area of concern going forward. So thank you so much to everybody from ACS for joining. Thank you, Russ, for the great introduction of this event. Thank you, Christopher, for setting it up. And thank you again to all of our panelists for joining us. I think most of the Q&As were able to be answered by professors and lawyers while they weren't speaking. But if you have other questions, I'm sure you can find these people later on one of the 18 social media or at their email. So thank you.